This is a screenshot video. Uh, the notes that I have up on the screen start with capacity, but I'm going to later this week put a chart up on capacity to make up for the absence of a book, and I'll then do a screenshot video on that chart. So for now, I'm not going to discuss capacity, and I'm going to go into the last requirement of a valid contract, which is legality. And again, I know there's a reference made to the book, but I'll be able to deal with that simply in this screenshot video. It would make sense, and indeed it's the law of contracts, that a contract is not enforceable if it's contrary to law. But what does that mean? Well, there could be a statute that makes a contract illegal. I mentioned in the notes gambling contracts, but another type of an agreement that would be contrary to statute would be an agreement that charges too much interest. There are laws that set forth the legal limits on what can be charged for interest, and I'm certain you've heard of the term loan sharking. So if someone went to a person and borrowed money and the interest rate was in excess of what is allowed by statute, that would be an illegal contract, which then may cause difficulties for the person who entered into the contract because they can't be taken to court, and maybe the loan shark would use extra legal methods to enforce it. But what I want to focus on really is a practical aspect that attorneys and then perhaps paralegals run into, and that would be a contract that would be contrary to public policy. And more specifically, where we run into this would be contracts that contain covenants not to compete. Sometimes they're also referred to as anti-competition clauses or contracts. And I have an example in the notes, but let's just back up. We're looking at really two categories of contracts. One category would be a sale of a business, and a second category would be an employment contract. And let's first deal with sale of a business. If our client was to purchase a business from someone, a concern that we ought to have is the goodwill of the business that we're purchasing that could be destroyed if the seller of the business were simply to start a new business that would compete with our client. And so how we can deal with that is to have a covenant not to compete in the contract. And so I use purchasing a business that is a pizza business located in South Buffalo, and the concern is that we want to, if we were representing the buyer, have some provision in the sale of business contract that would prohibit the seller from competing. And we would be looking at two different categories in this covenant not to compete. One would be duration or time, and a second one would be scope. And what the law is in New York is that our limitations on duration and scope must be reasonable. So though ideally, as I point out, if we were representing the buyer, we'd like to have the seller agree that the seller will never sell pizza anywhere in the world forever, but that's not going to be in the range of reason. So what we would want to have in the contract would be a limitation in scope, and we would look at where the customers from the business come from, what is the advertising range of the business, and so on, and we could figure out a reasonable scope and in terms of geographical limitation, and for a period of time, my understanding, certainly over the recent cases in New York, would probably put us in the range of 2 years, so that the contract of purchasing the business would say that the seller for 2 years couldn't sell directly or indirectly pizza within a certain geographical area. And we certainly would want to have that in the contract to protect our client. Now, what I don't have in the notes, but what I want to talk about a little bit, would be a covenant not to compete in a employment contract. And again, we have our scope and duration, but I think a significant point that we should make is that we need first to have a key or significant employment position before the covenant not to compete would be allowable. And an example that comes to mind, some time ago in my practice as an attorney, I represented a tennis center, and they wanted to hire a new pro. Well, that's a significant or a key position. And the concern was, from the client's perspective, they didn't want the new pro to come in and perhaps develop a following and then go to a competing tennis center. So what we had in the contract was a covenant not to compete, where the pro, if he left employment, could not work for X number of months, and I think we had like 18 months as a tennis pro in a certain geographical area. And what we did is we considered where other competing tennis centers might be, and that guided us. And so that would be an example of a covenant not to compete in an employment contract. What I'd also want to point out is that in the employment contracts, there seems to be a trend, not only in New York, but nationwide, where legislative bodies have become involved. And the concern is that people's ability to earn a living will be hampered if these covenants not to compete for a person who's leaving an employment position. If such covenants would be too limiting. So that's something in the real world of practicing law that attorneys have to be careful about. But to sort of recap, if we have a sale of a business, or if we have an employment contract, the purchaser of the business or the employer hiring someone, if it's a key employee, would be interested in a covenant not to compete that would limit reasonably the ability of the seller to not engage in the same business within a certain geographical area, or the employee, if the employee was leaving employment, not to compete with the employer in that position for a reasonable period of time in a reasonable area. So that will conclude this screenshot video. And again, I'll have some material up for you on capacity. And I'm going to stop the video at this point.